All right, ladies and gentlemen, I'm going to read to you what is called the charge of the court. It's the jury charge. You do not need to memorize it because you will be given the original when you begin your deliberation. Charge of the court. Members of the jury, the defendant R.C. Curtis stands charged in count 1 of indictment with the offense of capital murder alleged to have been committed on or about the 21st day of October 2015 in Bexar County, Texas. The defendant R.C. Curtis stands charged in count 2 of the indictment with the offense of felony murder alleged to have been committed on or about the 21st day of October 2015 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that a person commits the offense of capital murder when such person commits murder as defined above, and the person intentionally commits the murder in the course of committing or attempting to commit aggravated sexual assault or robbery. 2. Our law provides that a person commits the offense of felony murder if he commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt or in immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. The following offenses are felony offenses other than manslaughter: aggravated sexual assault, robbery, injury to an elderly individual, aggravated assault. 3. Our law provides that a person commits the offense of aggravated sexual assault if the person intends.
Boom. Here's the emotional punch. The defense leans on RC's reputation as a family man, even comparing him to Santa Claus. But here's the danger. Juries aren't supposed to decide based on character, only evidence. Will they buy it or see it as a distraction? 36:07. Backhand index pointing right, microphone comment
with intent to deprive the owner of the property. 6. Our law provides that a person commits the offense of injury to an elderly individual if he intentionally or knowingly by act causes serious bodily injury to an elderly individual. 7. Our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the first person commits an assault as defined above, and 1. Causes serious bodily injury to another, or 2. Uses or exhibits a deadly weapon during the commission of the assault. A person commits the offense of aggravated assault causing serious bodily injury with a deadly weapon against a member of the person's family if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault and causes serious bodily injury to a member of the defendant's family. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. All right, ladies and gentlemen, each side will have 20 minutes to present closing arguments to you. Before they begin, is there any juror who needs a break? All right, State, are you ready to proceed?
Yes, Your Honor. The state would like to make initial argument and then reserve the rest of our argument for rebuttal. Morning, folks. Now, you just heard the reading of the charge. It's a mouthful. It's a lot to go through. So what I'm going to try to do is break it down a little bit for you, because some of the things you're going to see over and over and over in the charge. So I want to try to make that as clear as I can. Now, first of all, you have 2 counts in this case. Count 1 is capital murder, and count 2 is what we call felony murder.
Right here, the state drops its bombshell: DNA in the victim's mouth, rib fractures, and a brutal assault. This is where prosecutors tie the science with the story. It's graphic, it's emotional, and it's designed to lock in guilt beyond a reasonable doubt.
Why this offense was committed. And that's exactly right. The reason that we have multiple paragraphs is not because we're throwing things against the wall. It's because the facts fit those paragraphs for what he did. That's why we do it. Wouldn't you want us to be thorough and have those types of theories presented to you to give you, the jurors, those options, those abilities to prove the case? Now, another important aspect is that you have to return a unanimous verdict in regards to the counts, not the paragraphs, as to the counts. For example, count one, you have paragraph A and you have paragraph B. 6 of you can say, I believe he, with paragraph A, that's committing the aggravated sexual assault and also intentionally causing the death of Paula Boyd. And then 6 of you can say, well, I believe he intentionally caused her death while in the course of committing robbery. That equals guilty of capital murder. You don't have to be unanimous on paragraph A. You don't have to be unanimous on paragraph B. As long as all of you agree that it's one or the other, it equals guilty. Same thing goes for count 2, the felony murder. We have 4 paragraphs there. Aggravated sexual assault, robbery, injury to elderly, and also the last one is aggravated assault against a family member. Same thing. For example, 3 of you could agree on the first one, 3 on the second, 3 on the third, 3 on the fourth. You don't have to be unanimous in terms of the paragraphs, only the counts. As long as you all agree on the count, it equals guilty. You also have heard throughout the trial, and also in voir dire, and the judge read it here on the charge, the term deadly weapon. Now, we talked about that. A deadly weapon is anything that, in its use or intended use, is capable of causing death or serious bodily injury. And you agreed with us when we gave the examples that